Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome to Legalese 123. I'm your host, Missy K. How is everybody doing out there today? Today is my very first live. So we're going to see how this goes. It's going to be very, very interesting. Um, I I don't know how it's going to go, but here we go. So I thought I would come on live and introduce myself and tell you a little bit about me and tell you what we have going on today. So as you see, I've got my lovely knits today. I know this is not a knitting channel, but that's okay. I just want to show you what I have today. This is my Il Amani yarn, and I made it sort of like in a lattice pattern. It's very, very soft. I don't think I'll be doing knitting every day, but because I don't have all of those items, but we'll show you what I've been creating. I haven't been knitting lately. I'm doing this. So if you like this, please definitely go down and do a like and a thumbs up for me and subscribe. Subscribing is free. As I stated that I will be going to a holiday party in December, and they're going to say, "What is it that you do?" And I'm going to say, "Well, I do this thing on YouTube. I'd like to call it LawTube. That's what some people technically call it. So we'll see. I got a lot of uhs in there. Anyways, I try not to say but here we are. I am modeling my channel after two people that I really admire. Emily D. Baker. She is a lawyer. She has been practicing law for 20 plus years. She came from LA. She lives in Tennessee right now. She does LawTube. She goes through the cases and breaks things down, etc. She doesn't get caught up in the drama. She just pretty much tells you things how it is, etc. So I really like her content and I really like her personality. The other person that I am modeling my channel after and who I so adore is attorney Melanie Little. She is amazing. So I'm shouting them out because if you haven't heard of them or you haven't seen them, definitely go and look at their pages because they are amazing. Emily, she has like a format where she says, this is what I'm going to cover. And every once in a while, she'll go off topic, but very rarely. Attorney Melanie Little, wow, her show is just amazing. She can just fly off the handle and go left, right, and center. And she's like, oh, squirrel over here, and let me pull this up. And she does things on the fly. People send her stuff left, right, and center. And she's just like lickety split and got it up. She's like her own news program. She does have some things that she says, okay, this is what I have for you today. And she goes down that rabbit hole. But every once in a while, she'll come back and if there's breaking news or what have you, she pivots really quickly and she is very amazing. There has been a lot of trolls out there lately, trolling some of the people on the internet for the variety of opinions and stuff of that nature. I don't play into that. Again, I'm just starting out. So, if you put comments and stuff in the chat, then, we'll see how it goes and go from there. But again, I'm just starting out. So you don't know me. I don't know you. So welcome. The other reason why I started this channel is that I got very involved in watching court cases. I wanted to become a lawyer myself. I was unable to become a lawyer for life choices, decided to pursue other avenues. And now I am in my upper years. And is it even worth it to go to law school? If you do go to law school, then you have all those funds that you have to pay for school. And then ultimately you go and then you practice law. Well, what kind of law do you want to practice? What do you want to be when you grow up? I'm already grown up. What kind of law would you like to practice? But here I am. I'm here in my own household and I'm talking to you. And so it's kind of fun just to see what's going on out there in the world and bringing it to the masses. And I can do this from the comfort of my own comfy chair. So, this is what I've decided to do, and hopefully you will join me along in the journey. So, if you're new here, definitely say something in the chat and say hello, and I'll say hello back. So, we'll see how it goes. What else do we have for you today? We've got a lot of things going on today. The world is bananas today, but I want to take a moment and share this with you. So, today we remember the lovely souls from the Idaho 4 victims. We have Kaylee Gonsalves here, Madison Mogan, Xana Kernodle, and Ethan Chapin. They lost their souls on this very day, and we're not going to name who we know who did it. Today is a remembrance of the lives that were lost. And if you know me personally, you know that I am very connected to this case. It is very devastating to me and a lot of friends that I have in that community. And we are very grateful that the case has come to an ending and that the families have finally received answers that they were looking for, and that hopefully, these lovely souls can finally rest in peace. As for the two surviving victims, Dylan Mortensen and, oh boy, her name is escaping me. Anyways, her name's escaping me. Dylan and Bethany. Yes, Bethany Funk. Dylan Mortensen and Bethany Funk. Those are the two surviving roommates. We remember you and hope that you are having peace in your life and that you are getting the help and therapy that you need in order to continue on. So we're going to take a moment of silence for remembering these lovely souls. So give me just a second here and we'll take a moment and a deep breath. Again, thank you. I will do a deep dive on this account. We unfortunately haven't gone through it just yet. I wanted to give it a chance to breathe for a little while because things were still so highly charged in reference to this case. So I wanted to do it proper justice. So we'll come back and we'll visit it. So if you're watching, put a comment and say hello so I can see who's watching today. And don't forget to like and subscribe if you haven't already. All right, so we're going to go ahead and move on. So I was going to today talk about the Corey Richins case. A lot of things are happening in that. If you don't know the Corey Richins case, she is accused of killing her husband, again, allegedly, with a overdose of fentanyl, 5 times the legal limit. She gave him a Moscow Mule, and then in the middle of the night, he passed away. And she was like, "Oh no, he passed away." And it wasn't discovered until about a year or two afterwards that she had some culpability in the case because they cracked her phone. We talked about cracking phones yesterday. So she is back in the news. She's got a lot of things going on in her case. Her case is scheduled to go to jury trial in early January. So a lot of behind the scenes things are happening currently right now. So we're going to go over her, but something else popped off yesterday, and I thought it was more important to push that case aside and talk about this case. So if you haven't heard me talk about Aaron Spencer, we're going to do, again, a road so far and talk just a little bit about who he is. So it's Aaron Spencer versus Arkansas. It's a case out of Lonoke County. Aaron Spencer is charged with secondary murder of a 37-year-old man named Michael Fossler. Now, Michael Fossler is 67 years old, and he had been charged with several sexual offenses against Spencer's daughter. And the judge in the case, Barbara Elmore, let Mr. Fossler out on a $5,000 bond. By the way, don't know exactly what's happening in Arkansas or what's happening on the World Wide Web, but Fossler, there's not very many pictures of him. He used to be a sheriff, I guess, in Indiana, and they've like wiped his pictures off of the face of the earth. So there's only just a few pictures of him. So what is happening? So on October 8th, Spencer had woken up and found his 14-year-old daughter missing from her bedroom. Their dog was barking. He went to go find out what was going on. He went into her room and found out she's not there. What happened to her? She's gone. So he went to go look for her and got in his truck, found that Fossler was in and around the area, and kind of ran his car off the road, found out that his daughter was in the truck with Fossler, and that there was an altercation and Spencer had shot Fossler dead at the scene. So it garnered significant attention because in the beginning, the case was the state requested that there was a gag order to preserve the integrity of the jury pool. Well, if Spencer's attorney said, "What the heck?" So his family was under a gag order. No one was able to talk about his case. No one was able to say what really happened. And so it just turned into a big, I would say, kerfuffle in the beginning because nobody was talking about it. And then all of a sudden, there was a gag order and nobody could talk about it. So Aaron Spencer couldn't get his side of the story. The state said, nobody can say anything about it. So then it just sat stagnant for a while. Well, finally, Spencer's attorneys said this is improper. So they took it up to the state level, and the State Judiciary Committee stated that it was improper and that they couldn't have a gag order. So the gag order got lifted sometime in late summer of this year. So finally, we're starting to get some information about this case. Right now, we just have little bits and pieces, but today there's going to be something big. So how did Spencer know that Fossler had his daughter? So apparently Fossler had been grooming his daughter and assaulting her multiple times. Fossler had been released on a low bond, $5,000, and that he had no contact to speak to Spencer's daughter. So he had 43 counts of sexual assault and internet stalking on a minor, and he was arrested in July of 2024. So people want to know, is Aaron Spencer justified in his actions for, you would say, I guess, hunting down Fossler and getting his daughter? So again, we always say that these questions will have to be answered in a court, and a jury of his peers will make the determination. And the same judge who released Fossler, Barbara Elmore, also indicted Aaron Spencer. I think there is only 2 judges in the county, and that is going to be a bone of contention. Should she be recused from the case because of her connection and her, one would say, lack of awareness that she let Fossler go, and that, one thing led to another, and he ended up allegedly kidnapping Spencer's daughter. So what does one have to say in reference to that? We don't know. We will have to find out. Will Spencer's attorneys ask for her to be recuse herself? Will Spencer's attorneys ask for a change of venue? We don't know just yet. So right now we're in limbo. So on December 4th, 2024, the state had filed a motion to set a gag order. So in July, Fossler was put on those charges. I don't remember the exact date of the incident, but so there's a gag order in the case. And then the order was granted December 10th by Judge Barbara Elmore. The defense appealed the gag order, and it was lifted just June of 2025. So there was a pretrial. This was an old presentation I put together. There was a pretrial hearing on August 8th that has been changed. The selection was supposed to happen in September, but they asked for a continuance. So this was an old slide. So we are now going to switch gears because there has been a motion in limine filed by the state. So we're going to look at, see if I can show you the docket currently. So let's remove this and let's add this to the stage. Okay, so this is the current docket of Arkansas versus Aaron Spencer. And it's kind of a little hard to see, but you can see that they, both the prosecution and the defense had a joint motion to extend discovery and motions and filings, etc. And then Barbara Elmore who is the judge, stated that she wanted to have order of extended deadlines. So as you can see, all motions are to be filed no later than November 24th, and all of responses shall be filed no later than December 3rd. That is, she's moving the case along, right? So when that happens, so we're in what's called pre-trial, right? And in this stage, the defense and the prosecution sort of lays out their case. They say, this is what we propose, this is what we think that he did, this is the experts that we're going to have that said XYZ. The defense goes back and forth. Each one says they don't want this to come into trial, they don't want that to come into trial. So this is what's called the pre-trial motions, where they go back and forth and they file the papers. So they file motions that say how the case is going to be run. And it is kind of controversial because in the Corey Richins case, the defense in that case is claiming, well, the prosecution is just telling everybody everything. Well, they have to. That's part of their motions. They have to state what their case is. And sometimes they can be a little dramatic, but again, they have to state the facts. So when the prosecution puts on their case, they're telling you what they know in the case. They shouldn't be embellishing, they shouldn't be putting in their thoughts and opinions, etc. Some are cleverly written. Again, you have to remember that court cases are about theatrics, right? It is about presenting a case. It's about bringing it to a jury who are the finders of fact. It's about discussing a case, and I don't want to say make it entertaining, but you have to put in elements, whether your words or actions, etc., that state your case, but yet try to help defend and advocate for your client as much as possible. On the prosecution side, they're advocating for their client, which is either somebody who's been harmed or somebody who is deceased. They're advocating for the families and the victims. On the defense side, they are advocating for the accused. So let's go ahead and look at the state's current motion in limine. This was filed on November 7th, and it is laying out the case. So it says, comes now the state of Arkansas through Chief Deputy Prosecuting Attorney John Higgins, and for its response to the defendant's motion in limine to exclude evidence, states, Aaron Spencer, hereinafter will be known as Spencer, is charged with murder in the second degree of killing Michael Fossler, herein known as Fossler. The chain of events leading to Fossler's murder began on July 8, 2024, when the defendant arrived at Leanna Higginbotham's house, an acquaintance of Fossler, and told her that he had can't say that word on YouTube. They don't like that word. His minor daughter and wanted Fossler's phone number and address. Spencer told Higginbotham, "Don't call anyone and don't call the police." Out of concern, Higginbotham spoke with a family member about her interaction with Spencer. Her family member, a mandated reporter, was required to report the grape allegations to law enforcement and reported them to the Lonoke County Sheriff's Office. That same day, Sergeant John Ingram and Deputy Brian Duke of the Lonoke County Sheriff's Office responded to Spencer's residence to open an investigation about the grape allegation concerning his daughter. The interaction was recorded by Sergeant Ingram on his body-worn camera and a transcription of the relevant portions. Oh boy. They are included. Sergeant Ingram's asked Spencer, "Is there any truth to this?" Spencer replied, "I don't know." While attempting to investigate the allegations, Spencer was mainly concerned about the identity of the mandated reporter and his beliefs in the inadequacies of the judicial system. Sergeant Ingram stated to Spencer, "We still don't live in a country where you can take the law into your own hands?" ? Spencer responded, "BS." Eventually, Spencer's wife, Heather Spencer, provided information to the deputies regarding the assault of their daughter. Spencer's daughter was interviewed at the Wade Knox Children's Advocacy Center, can't say that word, Center on July 8th, 2024. At Cabot Police Department obtained a warrant on July 11th, 2024 for Fossler's arrest on a 1 count of grape and 1 count of internet stalking of a child, both Y felonies. Fossler was arrested the same day and taken to Lonoke County Jail. Fossler was seen in his first appearance hearing after the arrest by a Lonoke County District Court judge on July 12, 2024, and his bond was set for $50,000. Fossler was ordered not to have any contact with the minor, a violation which would result in his bond being revoked. Fossler made bond on July 17, 2024, and was released on conditions of a pre-trial release, including the no contact order. On July 8, 2024, at 1:12 a.m., Heather Spencer called 911 to report their daughter was missing. Heather Spencer said they found their daughter's bed made up to look like she was asleep, but was not in the bed. Consistent with Spencer's belief, expressed to law enforcement that on July 8th, 2024, Spencer proceeded to take the law into his own hands. Spencer later told investigators that he immediately got his truck to look for Fossler, stating he was vigilant for him. Spencer left his home traveling westbound on Highway 236. Spencer stated he was turning onto Highway 31 at the intersection of Highway 236 and saw Fossler's white Ford truck. Getting interesting. All right, so he was at the intersection of 236. He saw Fossler's white truck passing him, turning on Highway 236 eastbound, backwards towards Spencer's house with his daughter in the passenger seat. Spencer turned around and began following Fossler. He was honking and flashing his lights in an attempt to stop Fossler. After following Fossler for approximately 6 miles, Spencer struck Fossler's truck containing both Fossler and Spencer's daughter. As a result, Fossler's truck was rammed into a ditch, striking a wooden entry gate post. After exiting his vehicle, Spencer then began to fire on Fossler. Spencer continued to fire a total of 16 times. 15 of the 16 rounds entered Fossler. Oh boy. After firing, Spencer pistol whipped Fossler in the face. Then, for the first time that night, Spencer called 911 at 1:34 a.m., stating, "Michael Fossler is a effing dead on the side of the road for trying to kidnap my daughter. I had no choice." Ooh, boy. So, what do you think of that? Again, we knew some of this information, and it's interesting how now the state has put it, again, this has to state their case, right? So they're putting it out there, and it's very interesting. It's a very interesting tell. Tell me what you think so far. All right, let's continue on. In fact, Spencer had multiple choices that night. Spencer could have called 911 once he discovered Fossler and his daughter. Spencer stated in his interview that he was driving so fast that he could not unlock his phone to call 911. However, a forensic examination of his phone from the minutes leading up to Fossler's killing paints a different story. Not only does the examination show that his phone was unlocked, but was in use. Spencer had 1 minute, 39-second phone conversation with a family member at 1:16 a.m., received multiple text messages marked red, and called his wife twice around 1:31 a.m. before calling 911. Spencer also had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night. Spencer did not want police involved when he initially discovered his daughter was sexually assaulted, nor did he want them involved when he found Fossler with his daughter. Spencer's understandable rage did not give him the legal right to kill Fossler. His belief espoused on July 8th, 2024 to Sergeant Ingram that it was BS, that we still live in a country where we cannot take the law into our own hands, runs counter to our entire justice system. So, is this vigilante justice? Does Spencer have the right to defend himself? Now, he's not on his own property. He went searching for his minor daughter. So these are some really great questions that are going to come up in the pretrial motions as well as in his case. Let's continue on. We're on page 4. All right. The evidence that the defense wants to exclude regarding Spencer's statements, wherein he clearly indicated he did not wish police involvement in his daughter's rape investigation. His implicit comments that he could not take the law into his own hands and should not be charged with a crime are directly related to his actions on the night of October 8th, 2024. Not only are the statements by a party opponent, the evidence is clearly admissible under Arkansas Rules of Evidence 404B, which allows evidence of other acts that are admissible to prove motive, intent, plan, and knowledge. Evidence is relevant if having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Spencer's affirmation that one can take the law into one's own hands makes the extrajudicial act of killing Fossler more probable, done without any consideration of the law on self-defense and the defense of others. Wherefore, the state requests this court to deny the defendant's motion to allow this testimony to be elicited by the state in their case in chief as statement by party opponent under the Arkansas Rules of Evidence. And they continue to elicit more information here. We'll take a look at what the defense filed a motion to exclude. So we'll see what they have to say as well. Probably should have started there, but here we are. All right. So they have a transcript of the conversation between Sergeant Ingram and Spencer and the other party. Hey, sir, he's gonna, by the way, are you Aaron? Y'all creeping around here? What's going on? We're not creeping around here. We're just trying to make contact with you. With me? Aaron Spencer? What do you need to make contact with him for? Well, we've got a report from a mandated reporter that your child may have been involved with a grape situation, so we needed to talk to you about it. Who's the mandated reporter? Well, it's a mandated reporter. Cool. Who's that? Well, I'm just letting you know. So, I mean, is there any truth to this? And I don't know. You don't know. Well, would you like to talk to us about it? I'm not sure. Okay, we're just I'm not sure what's going on. We're just here to help. All right. Next page. Hang on just a second. I got to move my mouse from this microphone. We're getting a lot of feedback here. All right, let's see what's next. Do you got any more information than that? Well, here's what we're told. We received a call from blank to our dispatch. Who called you? Sorry, a mandated reporter had to call us. Someone that you spoke with earlier is a mandated reporter who's under, she has to report what she heard you say. And who's that? So you heard me say what? What did I say? Has something been called before? What's that? Has something been called before? No, but I'm explaining it. If we get a call saying that there potentially may have been a child who was raped, then obviously we have to respond. The person gave your name as the person who was the father of the child who may have been raped. Okay, so obviously we have to come and talk to you and see if there's any truth. Who called and made these allegations that something might have happened? So he's very concerned as to who made the report. Sir, that is irrelevant. We're just asking. It's not irrelevant. It is. It really is. I mean, we're here for this child. Then let's play the guessing game then, right? I mean, come on. No, you probably know who you spoke to today about looking for some person's address. I mean, who? A Mr. Blank. Was it Mike Folsom or something? Who's that? Okay, well, I mean, we're trying to help you, okay? Are you? Yes, but we can only help you as much if you're not going to talk to us. Then obviously we can't. I'm just wondering who called you saying that there was somebody that was harmed and that no one said anyone was being harmed. Harmed? Harmed, okay? Yeah, I'm carrying. Yeah, I see you're carrying. Still, I'm keeping my hands up here so nobody gets, that's fine. I mean, again, we're not here to cause, next page, any problems for you. Okay, we just need to investigate. We're not the bad guy. We're just trying to help you. Yeah. I understand I understand your emotional feelings. Let me ask you a question. So I understand. Let me ask you a question, okay? Yeah, yep. If the allegations are true and there was a child who was raped, okay, what's going to happen to that man when you arrest him and prosecute him? This and that. 3 to 5? What, he's rolling around cruising, grooming? Like I said, I understand. I have a kid. No, seriously. Seriously. So if that happened to your kid, right? It did. And it did. And so you went to the police? Uh-huh. And how'd that work out? Where is he? Where's the person who's accused today? So this is body worn camera, and this is a transcript from the body worn camera of them talking to Aaron Spencer. In prison. He's in prison. Is he serving life? No. He's going to get back out, isn't he? Like I said, I understand. He's going to get back out and he's going to go around and F more kids, okay? So you don't think that it's logical for people to come to the police when they can't do anything about the situation. If somebody was harmed, yeah, but I can say, hypothetical. Let me ask you this, okay? Let's say, for instance, someone was raped. Uh-huh. And let's say the father, rightfully so, not rightfully so, but understandably so, was upset. Took the law into his own hands, understandably. Trust me, I understand. And does something. And that father ends up going to prison. Where does that leave that little girl? Why would the father Why would that father go to prison? That would be weird. Hypothetically. Hypothetic, right? Hypothetically, if he does something, we we still don't live in a country where we can take the law into our own hands, okay? Ooh, so they're clearly sort of defining where you can and cannot do things in the court of law. I guess it's not really court of law, it's sort of like a vigilante sort of thing. Spencer says, BS. Ingram says, okay, well, and then Spencer says, if the judicial system can't do a better job, okay, well, then you'd have to face the consequences and possibly take charge with manslaughter or, well, hypothetically, maybe the rapist and that father can share a jail cell, and maybe that rapist could be the father's little FB. You can read it for yourself. Well, that wouldn't happen. You know what I mean? But you know who pays the price of all of this, right? It's the child, ultimately. Yes, it's the child, obviously. But see, here's the deal. Her life was already ruined now, hasn't it? Yep. So don't ruin it anymore, says the officer. So what can we do then? Can you guys get him? Can you put him in prison? Well, I mean, we have to do our investigation, obviously. So is that the end? It looks like it's the end. All right. So that is the transcript from the, gotta move my mouse here. That is the transcript from, the body-worn camera that Officer Ingram and another officer had in reference to Aaron Spencer and discussing what is going to take place prior to A, Fossler being arrested, and B, before Spencer had altercation with Fossler. So let's see if we can go through and see what the defense has to say in reference to their motion to exclude. Let's see. All right. Well, we'll go over this one because this one is really interesting. Let's see if I can share this one. All right. Let's see if I can do this one. Okay. So this is a motion in limine from the defendant. Let's see what it looks like on screen. Oh, I need to share it. Add to the stage. Okay. Oh, let's see if we can make this bigger. Can we make this bigger? I'm not sure. Let's see if we can make this bigger. Does that make it bigger? Oh, a little bit. Here we go. All right. So now comes the defendant, Aaron Spencer, by and through his attorney, Michael Keel, at Lassiter and Casanelli, and for his motion states, the state discovery file alleges officers found a glass smoking device in the patrol cruiser where they were detaining Aaron Spencer. At the scene on the night charged of the act, Spencer demanded a blood test to confirm he was not a drug user. The state did not file any charges related to the device. This court must exclude any reference to and or evidence about the glass smoking device. Such evidence has no independent relevance and does not fall. Oh, I'm going to have to sneeze. Hold on just a second. Oh, excuse me. Such evidence has no independent relevance and does not fall into any of the listed or known expectations. General prescriptions for, that word says proscription or on character evidence, further, any probative value that the evidence has, which Spencer does not concede, was grossly outweighed by the dangers of unfair prejudice and confusion of the issues. Prior bad acts evidence must be independently relevant to the main issue, relevant in the scene of tending to prove something material point rather than merely to prove that the defendant is a criminal. Even in a relevant Rule 404B, evidence may still be excluded under Arkansas evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusion to the issues, or misleading the jury. The state is not entitled to introduce evidence of other offenses to persuade the jury that the accused is a criminal and thus likely to have committed the crimes he has been charged with. Specifically, proof of other crimes is never admitted when its only relevance is to show the defendant is a man of bad character and or addicted to crime. The evidence at issue has no independent relevance to the charged act, whether Spencer possessed the glass smoking device, something he bitterly disputes, has no bearing on whether he knowingly killed the alleged victim and whether he was justified in doing so. The evidence is irrelevant and admissible accordingly. Instead, this evidence is the worst kind of propensity evidence meant to encourage the jury to find Spencer guilty in accordance with his poor character as a perpetrated drug user, despite no proof of that in this case, rather than evidence associated with the charge offense. Any marginal relevance the evidence may have, which Spencer does not concede, is outweighed by the dangers of the confusion of the issues and unfair prejudice and must be excluded pursuant to Rule 403 accordingly. The trial would become about whether Spencer is a drug user rather than he committed a crime or was justified in killing the alleged victim. And a particular prejudicial when, as here, the proffered evidence connects a party with a highly charged public issue, such as narcotics. The danger of unfair prejudice from admission of drug-related evidence is great because of drug offense is the kind of crime for which a jury may feel a defendant should be punished regardless of his guilt as to the charged offense. This court must exclude the evidence pursuant to Rule 403 accordingly. The evidence does not fit any exception listed in 404B, and in fact, precisely the type of evidence that Rule 404B exists to keep out. Further admission of this evidence would violate Spencer's due process rights. This court must exclude the evidence at issue accordingly. Wherefore, the defendant respectfully requests that this court enter an order precluding the state from offering any evidence of the glass smoking device during the trial in this matter, and alternatively for a hearing whereby the state may specify which exception to Rule 404B it believes applies, and where the court may determine whether such evidence will be admissible. Respectfully submitted by Michael Keel. All right, so that's not the one that we were looking for, but let's see if I can find the other motion. Let's see. Motor continues to dismiss. So they filed a whole bunch of motions. They filed a motion to dismiss the felony information on Fifth Amendment grounds. Again, Judge Elmore hasn't ruled on any of these things. They have not had a court date to go over any of these things. Let's see. Okay, let's see if this is it. This looks like it's it. So let's go ahead and remove this. And let's see if we can add the next one. Let's make it a little bit bigger so those at home can read along. But we have to share it first. Where'd it go? Let's see if this is it. 1 second. this one's it. So let's see if we can make it just a little bit bigger so you can see it at home. Oh, here we go. All right. Comes now the defendant Aaron Spencer by and through his attorney Michael Keel of Lassiter and Casanelli for his motion states. Decedent Michael Fossler was charged with multiple felony counts for sexually assaulting Spencer's daughter. Fossler was arrested on July 11th, 2024, after Spencer's daughter made initial disclosures on July 8th, 2024. The state's discovery file contains a report from the Lone Oak County Sheriff's Office Deputy John Ingram about a meeting with Leanna Higginbotham and her daughter Paula McFarland on July 8th. The report alleges Higginbotham and McFarland told Ingram that Aaron Spencer had requested details about their mutual friend, Michael Fossler, and that when Higginbotham and McFarland asked Spencer why he wanted Fossler's information, Spencer told him that Fossler had raped his teenage daughter and allegedly begged for them not to call the police. Ingram's report then notes that he spoke with Spencer at his residence and that he was extremely angry at first and refused to talk about the possible rape, but then calmed down, cooperated fully with law enforcement's investigation into Fossler. This court must exclude any reference to or evidence about Spencer's conduct July 24th. Such evidence has no independent relevance and does not fall into any of the listed or known exceptions into Arkansas Rule of Evidence 404B. General proscription on character evidence. Further, any probative value that the evidence has, which Spencer does not concede, is grossly outweighed by the dangers of unfair prejudice and confusion of the issues. All right. So we're going to pause there for a second. Again, not a lawyer, but this is just sort of common knowledge, and this is kind of what I know. If something is going to, you have to say the evidence that's going to come in. If it's more probative, meaning if it's going to go ahead and lend credence to the case, then it should come in. If it is going to sort of taint that person and put them into a bad light, character, right? Bad character, such as we're talking about the drug he found a pipe in the car, it wasn't his. It would label him as a drug user, and that shouldn't come into evidence. So this is what the defense is saying, that his character and the demeanor with which he had an interview shouldn't come into play because it would paint him as this person. So we're going to go ahead and continue to read on. All right, let's see. How do I get this back up here? All right. The evidence is not relevant and is inadmissible pursuant to Rule 401, 402. Spencer's conduct on July 2024 has no bearing on whether his use of force against Fossler more than 3 months later in response to Fossler's kidnapping, abusing, and possibly eliminating his daughter as a witness in his own criminal case was justified. Now, do we know if that is factual evidence? Do we know if Fossler was going to eliminate his daughter? I mean, again, we're speculating here, right? One would say, oh, we're going down this path and we're just, choosing to believe that this might have happened. One doesn't know what happened. One doesn't know what might have happened. We can only conclude what happened. You can only go off the basis of what actually happened. Remember, you're the juror. You're the finder of fact. You get all the evidence, you put it together, and you make a decision of whether or not you think Spencer is guilty of committing this crime. Is he justified in committing this crime? And also remember that he is innocent until proven guilty. So let's continue. So they're saying that this evidence must be excluded and is irrelevant according to evidence of other crimes, wrongs, or acts are not admissible to prove character of a person in order to show that he acted in conformity with therewith. It may be, however, it may be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, and absence of mistake or accident. Prior bad acts evidence must be independently relevant to the main issue, relevant in the sense of tending to prove some material point rather than merely to prove that the defendant is a criminal. Even if relevant under Rule 404B, evidence is still must be excluded under Arkansas 403 if it is probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury. See, that was what I was trying to allude to, is that if his prior bad acts, say he had said these things, etc., does that lend to the question of whether or not is this misleading the jury? The state is not entitled to introduce evidence of other offenses to persuade the jury that the accused is a criminal and thus likely to have committed the crimes he has been charged with. Specifically, proof of other crimes is never admitted when it is only relevance is to show the defendant is a man of bad character and or addicted to a crime. The evidence at issue has no independent relevance to the charge act. Whether Spencer asked associates of Fossler for information about Fossler more than 3 months prior to the charged acts in this case has no relevance to the charged acts. Whether Spencer was angry and or initially refused to cooperate with law enforcement into the investigation of Fossler, an investigation that he then cooperated with fully, has no relevance to the charged acts either. Such evidence may be relevant if Spencer is alleged to have stalked Fossler and killed him at his home or out in public. However, that's not what happened here. Rather, Spencer awoke in the middle of the night to find his teenage daughter missing and happened upon Fossler's truck as it turned down into Spencer Street while out searching for his daughter in his truck. Spencer was not looking for Fossler, rather he was looking for his daughter. He just happened to find Fossler with his 14-year-old daughter mere months after Fossler's arrest for abusing her. What followed was a lawful use of force in defense of his daughter and himself. So that is what the defense is going to go for. They're saying that this is a lawful right to defend. So that's going to be very interesting. Let's continue. Instead, this evidence is the worst kind of propensity evidence meant to encourage the jury to find Spencer guilty in accordance with his character for having sought out Fossler's information to handle the issue himself, despite no actual proof of such, to encourage a vigilante narrative that is simply belied by the actual facts of the charged offense. Rather than evidence associated with the charged offense, any marginal reference the evidence may have, which Spencer does not concede, is outweighed by the dangers of confusion of the issues and unfair prejudice and must be excluded pursuant to Rule 403 accordingly. The trial would become about whether Spencer had previously sought to handle Fossler himself in July 2024, rather than he was justified in killing Fossler in October of 2024 following Fossler's abduction of his daughter. The state will be able to argue some sort of pre-existing intent despite no alleged connection between Spencer's July 2024 comments and the use of force against Fossler in October 2024. This court must exclude the evidence pursuant to Rule 4043 accordingly. The evidence does not fit into any exception listed in Rule 404B, and in fact, precisely the type of evidence that Rule 404B exists to keep out. Further admission of this evidence would violate Spencer's due process rights. Wherefore, the court must exclude the evidence accordingly. Signed, Michael Keel. So, you've got both sides of the story, right? So this is what a court case is about. The defense files a motion. They want this thing excluded. And states the facts of the case. The prosecution then files their motion to say, no way. We don't like what you're saying. They're saying the state files a response to the defendant's motion to exclude evidence. And then they present their papers to the judge. The judge reads it. reviews the evidence, reviews their statements, reviews case law that they've stated in their papers. Sometimes the judge rules on it without having a hearing. Sometimes the judge goes ahead and has a hearing. Both sides argue their points. Then sometimes they rule from the bench. Sometimes later on they write up a order ruling later on down the line. But as I stated, Judge Barbara Elmore has stated to the participants, I have a little note here, that motions are due, as I stated, on December, let me find it, that all motions are to be filed no later than December 24th, and any responses to motions by December 3rd. So both parties, both sides, the prosecution and the defense, files their motions. We want to exclude this. We want to bring this person in, et cetera, et cetera, et cetera. And then they both say, no, you can't. Yes, we can. So they file motions back and forth as sort of a conversation, a discord between one another. And then, so the order was that all motions are to be filed no later than November 24th, and that all responses are to be filed no later than December 3rd. And then Judge Elmore stated that there will be a pre-trial hearing on December 17th. That means that perhaps she's going to collect all of the motions together. They'll have a hearing. Again, they might go ahead and talk about their motions, argue their points, etc., for her to rule on. There might be sort of like information in reference to talking about jury selection, polling questionnaires and stuff that they might ask jurors, potential jurors, to whether that not they can be seated on the jury. Talk about evidence that might come in, experts that might come in, and any issues and stuff that is related to the court preparations. So currently they are on track for this to happen. Again, pretrial hearing on December 17th. We don't know if it's going to be streamed live. We don't know if there's going to be cameras in the courtroom. We don't know if there's going to be a Zoom hearing. Again, that's another reason why we talk about these cases and why it's very, very important. And the reason being is that in some of these smaller instances, we try to bring awareness to each case. Courtrooms are public. You're supposed to go to the court and you're supposed to be able to see the court hearings, etc. So there's no shenanigans going on and that one person isn't being railroaded versus another person. It's only sort of, after the O.J. Simpson hearings did they start sort of what's called live streaming. And there's a big debate about whether live streaming a trial is good for people or if it's bad. It brings a lot of attention to a case. It might bring negative attention to a case, but it also holds people accountable, right? And that's probably the basis of everything. Is the judge being fair? Is the judge being biased? Is the prosecution unfairly prosecuting somebody? What's the evidence that's coming in? How is the evidence coming in? So we talk about the Karen Reed trial, right? If you haven't watched that, we're going to go into it on my channel. It's been out there. She's had 2 seasons of trial. She had trial 1, was a mistrial. Trial 2, she was acquitted, found not guilty. The only thing she was guilty on was her OUI. So it's important that we had eyes on that because you got to see things firsthand. Were people telling the truth? Were people being honest with their stuff? What happened in the police? What was the investigation there? And you, again, are the juror. You are the armchair juror of fact, and you get to see how everything plays out, and then you get to make the decisions for yourself. A lot of some judges are appointed, some judges are elected. So you, as a trier of fact, if you happen to be in that county or the district or the area where a trial is happening and you don't like the circumstances, you get to be the one to go back and say, hey, you didn't have what was you didn't do things properly. For example, in Karen Reed's case, we're talking about the Norfolk District Attorney Michael Morrissey. He's the head of the office. He's the head top of the person. He's the one that's in charge of the district attorneys. He's also sort of in charge of the Massachusetts State Police, right? So, and what they're investigating, etc. They kind of work jointly together. Michael Morrissey is an elected official. I can guarantee you that those people in the District of Norfolk, Massachusetts, aren't happy with him, and he may not be the district attorney when the elections happen again. I think maybe November of 2026. I think it's next year sometime. I don't know the exact date. So, talking about that, it's important that we bring these cases to light so you can see what your elected officials or appointed officials are doing in cases. And these cases might affect you, right? What if something happened to you, your family member, your loved one, somebody that you know that's closely, they're being charged with something that they may or may not have done? How does this play out in court? So these are examples of things that could happen to you or happen to anyone. And it's sad that this YouTube channel is about tragedies that other people have experienced. But if we don't learn from these cases, then how are we supposed to continue forward? How are laws supposed to be changed? How are laws supposed to be looked at and adhered to? So this is why it's important for us to bring these cases to light. Speaking of which, I have this for you. I had talked about this prior in one of my other streams in reference to Aaron Spencer. Aaron Spencer is running for sheriff. And I thought that I would show you what he has to say. So let's see what this looks like. I'm going to get rid of me and we're going to bring him up. And let's play this and we'll chat. All right.
Hello, Lone Oak. My name is Aaron Spencer. Many of you know my story. I'm the father who acted to protect his daughter when the system failed. I'm also a husband, a combat veteran of the 82nd Airborne Division, a contractor, and a farmer. And through my own fight for justice, I have seen firsthand the failures in law enforcement and in our circuit court. And I refuse to stand by while others face these same failures. That's why I'm announcing my candidacy to run for Lone Oak County Sheriff. This campaign isn't about me. It's about every parent, every neighbor, every family who deserves to feel safe in their homes and safe in their community. It's about restoring trust, where neighbors know law enforcement is on their side and families know that they will not be left alone in a moment of need. Together, we can build a safer, stronger Lone Oak County for every family. I'm Aaron Spencer, and I'm running for Sheriff of Lone Oak County.
All right. So let's go ahead and stop that. Woo! All right. What do you think about that? So Aaron Spencer is running for sheriff of Lone Oak County. How is that going to play out? He has a trial coming up. I do not know what's going to happen. It's going to be very interesting to see how this trial plays out, right? As a juror, you're not supposed to let your emotions dictate how you decide the case. You are supposed to let the evidence, quote unquote, speak to you. You're supposed to let the evidence come in and you're supposed to weigh that versus what the charges are. So it will be a very interesting case to find out whether or not the defense is saying he's justified in killing Fossler. The prosecution is saying no, he acted with malice, and that malice and forethought into there were other methods that he could have taken before taking the life of Fossler, and he didn't take those actions, and so therefore he should be found guilty of this crime. So again, he is considered innocent until proven guilty. Everybody is in a court of law, and we will just have to wait and see. But things are moving rapidly. Here we are, November 13th, and just a little over a month, we're going to see what the motions in limine and what's happening for pretrial conference hearing. And then we'll see if it does actually happen in January, as Judge Elmore has stated. Again, remember, I think that they might ask the judge to be removed. They might also ask for a change of venue. It is a very high profile case in their county. A lot of people probably have heard about it. Has the jury been tainted? So we'll see if those two questions come up in these next couple of months. So remember, again, I was going to talk about Corey Richins. I'll do another stream later today about Corey Richins and give you an update about all the stuff that's popping off with her. Because again, her trial is supposed to start in January or it's supposed to start in February as well. And again, they have all of these pretrial motions, etc., and a lot is going on behind the scenes before her jury trial starts. And one of them is change of venue has been brought up again. Is that going to happen? We don't know. And if they do, then everything will be postponed and pushed back, because with a change of venue, they have to move everybody and everything. And it's a process. So we'll do another stream on that. Brian Walsh. So I talked a little bit about Brian Walsh yesterday. Brian Walsh is competency hearing is scheduled for Friday, this Friday, the 14th at 9 a.m. Eastern time. I don't know if it's going to be streamed live, crossing fingers that it is, or have a camera in the courtroom. Usually Boston 25 or somebody goes into the courtroom. So we'll be covering that as well. If it comes up, I don't know if there's going to be a Zoom link. We'll see what happens. Remember that Brian Walsh is being accused of dismembering his wife, Anna Walsh, and putting her body parts all over the place. We had an evidentiary hearing that we went over I've had a 2-part series on that in my YouTube channel that I covered the last 2 days. He's coming up as well. His trial was supposed to start already. They pushed it back. He is being held in Bridgewater State Hospital right now for competency. Is he competent enough to stand trial? So his competency hearing is going to be tomorrow. And then if that is the case, and I am assuming that the judge will then talk about the next pretrial hearings and motions and when they think it's going to go to jury. So again, with the holidays coming up, I really doubt that they're going to go ahead and start anytime soon. I doubt there's going to be any trials happening between now and the end of December. So he too might be going on trial as early as January as well. So that's when courts start back up and start piling on. So we might have a lot of things to cover in the month of January. Well, so in reference to what else is going on in the world, so we did a moment of silence this morning for our Idaho 4 victims. It is a very sad day in that case. So I ask and implore you to go out and do something kind today. Do a random act of kindness. I am going to go meet up with a friend later on today. I am lending her this pink sort of fluffy jacket that she is going to use in an upcoming play. So that is my random act of kindness for the day. So go outside, go get some fresh air, go say hello to a neighbor, go do something kind for somebody, just as a way to express your gratitude. All right, let's see, I made some other notes. So I want to remind you again, if you liked this content, if you'd like to see some more, just starting out, you got to start somewhere in life, right? So I have 11 subscribers. Yay! I'd like to get to 50 by the end of this month. So please like and subscribe. Doesn't cost you anything. Just go ahead and do the YouTubey things for me and share this with your friends. Share it with somebody that you think might be interested. Again, we're all out there trying to learn new things and do new things. So hopefully you will Tell me what's going on with you. Make a comment below. Tell me what are your hobbies. Obviously, you see I'm knitting. Tell me what you're interested in, what's going on with you. Do you like this coverage? Do you want to see something else? Let me know, and we'll see what we can piece together. So that's all that I have for today in reference to Aaron Spencer. Hope you're having a great day. See you later on. Bye. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.